Lawyers for Mike Lindell were threatened by a federal judge this week with the potential loss of their law licenses in a case that was brought against Lindell by a former security official at Dominion Voting Systems. It is a defamation lawsuit. This former employee says, I was specifically targeted by Lindell. He has kind of cost me a lot here, with my life, my reputation, all that. So he's suing him for defamation. Just like Dominion is suing him for defamation, just like Smartmatic is suing him for defamation. You see how it goes. But anyway, Lindell's lawyers had to file a motion this week with the judge, and I guess they just didn't have time to do it, so they used artificial intelligence to write the motion. And it's a pretty good motion. I mean, it cited almost 30 different legal cases. Unfortunately, none of them actually existed. And the attorneys either didn't bother to check the citations or didn't even read the motion. They just typed it into ChatGPT and said, all right, this looks great. Here you go, Judge. Ha ha. Let's get out of here early today. The judge was pissed, and the judge could immediately tell, due to the numerous citations of fictitious cases, that this was written by AI. Here is what federal judge, U.S. District Judge Nina Wang, wrote in her ruling. The court identified nearly 30 defective citations in the opposition. These defects include, but are not limited to, misquotes of cited cases, misrepresentations of principles of law associated with cited cases, including discussions of legal principles that simply do not appear within such decisions, misstatements regarding whether case law originated from a binding authority, such as the United States Court of Appeals for the 10th Circuit, misattributions of case laws to this district, and most egregiously, citation of cases that do not exist. The report goes on to say, Judge Wang has threatened attorney Christopher Kocharoff and associated attorneys with the loss of their licenses and is demanding an explanation. She continued in her ruling. Not until this court asked Mr. Kocharoff directly whether the opposition was the product of generative artificial intelligence did Mr. Kocharoff admit that he did, in fact, use generative artificial intelligence. After further questioning, Mr. Kocharoff admitted that he failed to cite-check the authority in the opposition after such use before filing it with the court, despite understanding his obligations under Rule 11 of the Federal Rules of Civil Procedure.